Well, we want to first off just thank everyone that's here in the office for joining us this evening, as well as everybody that's online. My name is Anthony Guerreri. I'm one of the partners here for our company, Evolve Financial Partners. And tonight we have a special treat. We're going to be discussing and focusing on the 7th money milestone as part of our education platform, right? We have a 7 money milestone process. Last one, number 7, is estate planning. And that is one of the most important parts of the estate planning process, the financial process, I should say. And I would say that the vast majority of people, in my experience over 20 plus years, this is the one people fail to execute.
Yes, I'm on the call.
Wait sometimes until it's too late. And most of the reason is people just don't understand. They don't understand what the risks that they're taking. A lot of it is they don't want to make the time for it. They don't want to make the decisions, right? I've got a couple kids. What if something happens to me? Who's going to take care of them, right? That's a big question that usually, if you're married, right, you have some discussions around that. A lot of times you don't agree, right? Or if you own property, and you want to, who are you going to pass that on to? So I don't want to, do the presentation or anything, but all of this stuff is extremely important. And tonight we have an expert, an attorney here in the office with us, who's been practicing law for over 14 years. And she's been in estate planning for more than a decade, helping clients work through this process. And what I love about Lisa is that her approach. She's very patient. She takes the time to get to know you, but also to understand exactly what you need and then walk you through that process. And ever since we started working with her, we really appreciate her experience and her knowledge. So from this point forward, I'm going to turn it over to our attorney and expert. Can we give Lisa a big hand?
Thank you, Anthony, very much for having me. I'm very happy to be here. I'm excited to be here, and I appreciate you guys taking the time out of your week to come listen to this. It's often a topic that many people don't enjoy talking about, because we're planning for the what ifs in life. The should something happen to you, should you not be able to do what you can do now, how do we plan for that? So thank you so much for having me, and I'll try to make this as informative as possible. If you have questions, I want to answer your questions. So it can surely be a discussion as well. And I'll forewarn you, I'm terrible at sticking to slides, so I go off on tangents. I don't have that many. But I'm going to try to touch on everything. Okay, so we call planning for death, planning for incapacity. We create what's called an estate plan. That's what a lot of attorneys do. Thank you. All right, sorry about that. So what does estate planning mean? A full plan, most people come to me and the first thing that they say is, I think I need a will. Everybody who's heard that term, a will, okay? A lot of people come thinking they need just one thing, and it's one thing that's going to take care of everything that they have. A full plan usually is what people need. And a full plan should do 2 things, okay? It should assist you and your family while you are still living, if you need it. So in the event that you become disabled or incapacitated, or let's say we get dementia, Alzheimer's, okay? We have documents that we can create within an estate plan that can make something like that an easier process, especially when you own assets and property. We have to know who has the right to assist you in managing those things if you cannot do it for yourself. Okay. The second thing an estate plan should do is provide instruction and facilitate an ease of transition if, God forbid, you pass away. We are all going to pass away. I say God forbid a lot, but it's going to happen and we don't know when. Okay. So a lot of people, again, with the word will, don't understand what a will does and does not do. And so that's something I want to explore with you guys tonight, so that we can talk about what a full estate plan should do. All right. So a good estate plan should allow your loved ones to know who, what, where, and do what they need to do without a third party being involved in the process. When I talk about a third party, usually what I'm meaning is courts. Okay. So whether you have a will or you have nothing at all, your estate 9 times out of 10 needs to go to the same place. And that is probate court. Okay. In Illinois, if somebody passes away and in grand total, your estate has over $100,000 in it, you are supposed to probate that person's estate, the decedent's estate, within 30 days of their passing. Okay. Most people don't know this. A lot of people don't do this. Okay. There are ways to get around doing that with real estate and sometimes with other accounts. They are costly, and you're going to have title companies, you're going to have financial fees that you could avoid if you simply have an estate plan. Okay. So again, within 30 days of somebody's passing, if you have no will, go to probate, go before a judge, get court's approval for somebody to manage your estate. If you have a will, that will does not become into effect unless you go through the court process. Okay. And the threshold is $100,000. So let me just ask this question by a show of hands. How many of you own your home? Home or other real estate? You could say other real estate. But just the value of real estate alone usually puts people over this threshold. Okay. So if you have no other assets, usually most people, most clients have met this and they need to go to probate. So what is probate? Probate is the court process where we go before a judge and we say, Your Honor, this person passed away. Here is what they have. It takes about 6 months to notify creditors. Okay. We have to notify everybody's creditors so that they can come forward and get their debts paid from the estate first. We have to have somebody, family, friend, whomever is available to receive letters of office, all things that a judge must do with court involvement. So what goes off in my mind when I talk about court and what I want to go off in your minds is when you go to court, you need attorneys. Attorneys need retainers. Then after that, after we determine the full value of estate, hopefully all of us amass a whole lot of wealth, right? But if our estate is worth $3 million, the county and the state are going to say, okay, well, here's our chunk of that estate for doing this. Okay. Not to mention everything that goes on is a public record. Okay. So we want to keep your estates out of probate. We don't want you to have to pay the attorney's fees. We don't want the judge to be making decisions for you. If you have family, you have friends, if you have things, there's a much easier way to leave these things to them where they do not have to go before a judge. Okay, so it's expensive. All right. What can we do generally with an estate plan? We can protect your assets. We can protect them from creditors. We can protect them from taxes. We can protect them from a whole mass of things. We can leave assets to specific people. So a lot of people say, hey, my daughter married a gentleman and I don't like him and I don't want him ever to get anything that I have. We can do that. You have children that you don't want to leave anything to. You can leave it to a charity. You can do whatever you want. Well, I'll say whatever, but usually whatever you need. Most important things for people with families and minor children, you can pick guardians for children and pets. Okay, people leave money to their pets. You can do that. And then very importantly, leave money to minors or persons with disabilities. Again, if we have young children and God forbid something happens to us, our children cannot step in to inherit until they're at least 18 years old. Okay, so we need to designate in an estate plan who do we trust to manage those assets until our children can take. It doesn't have to be 18. We know most 18-year-old kids aren't necessarily the most responsible, so we can stagger it. We can do things like that in an estate. All right. Okay, so the easiest way to avoid probate is to create and then put your assets into a trust. There are two main kinds of trust. There is a revocable trust and there are irrevocable trusts. And you can do different things for different reasons with each of them. I will tell you that 99% of people fall into the category of needing what's called a revocable trust. Okay. And a revocable trust is a trust that you create. So let's say I, Lisa, create Lisa Perna Miller Revocable Living Trust. I can be the trustee of that trust. I can manage my assets during my lifetime and do whatever I need to do with them. I can amend it, change it, take things in, take things out, use the money that is in there for my own benefit. Okay, that's usually the situation that most people find themselves in, needing to use their assets. Um, the other kind is an irrevocable trust, and that trust, when you create it, cannot be changed. Okay, we had a learning experience, you and I. Most times, an irrevocable trust, the trustee is not the person whose asset it originally came from. So, if I created the revocable trust, I wouldn't want to name it the Lisa Perna Revocable Trust. I would name it something else, and then name a third party as the trustee. Okay, I could not be the beneficiary of that trust. I maybe would name my kids the beneficiary, but if that property that's in the trust is ever sold or needed to be liquidated, it is not me who can take or benefit from it. Does that make sense? Now, you think, why would we do this? Okay, there are reasons that we are so wealthy, which we all hope to be, that you want to defer paying taxes. You can put something into a trust, and it's not technically yours anymore, so you don't pay tax on that. Well, I'll go into it a little bit later. There are trusts called special needs trusts. Okay, and so you can create a trust for a person with a disability or a special need, so that technically the asset that is in the trust is not theirs, but they receive the benefits from it. And so we cannot have whatever is in the trust factor into their financial information when applying for government aid. Okay, so you can be very strategic about how you create the trust. And the trust, when a lot of people say, will and executor, the trust, you are the trustee of a revocable trust as long as you are living. And then you designate who you trust. I would say at least 2 to 3 people that if you could not manage your assets or you were gone, who you would trust to do that for you. Okay. So those are the different kinds of trusts. With trusts, also, you do not need court involvement. So sounds morbid, but you pass away Thursday morning, Thursday afternoon, your successor trustee can do what they need to do with your estate. There's no waiting period. There's no waiting for creditors to come forward. Things like mortgages. So let's say for real estate, you have a mortgage on the property. That'll need to be paid if this property is sold, but your trustee has the discretion. Do we sell it? Do we rent it? What's in the best interest of the beneficiaries? You also can choose to tell them exactly what you want to have happen to it. So that's the role of the trustee. Okay. And so advanced trust is kind of just another way to say, irrevocable trust or planning for people with special needs. We can use revocable and irrevocable trust together. A lot of times when you have parents that maybe have a special needs child, I advise them to create their own revocable trust. So their own property is in trust. And then we open a special needs trust. So they, as trustee of their trust, can transfer into their child's special needs trust. It just protects everybody in the event that something happens to the parents. We have a child or a disabled person. So we can use them together. As I said before, it's not factored into the individual's eligibility for Medicaid or government assisted when you have something in a special needs trust. Okay. All right. How can estate planning help me when I am still living? This is an area I feel really, really strongly about because I have so many people that don't do this, and then they find themselves in a situation where it really could have just avoided a whole ordeal. I had somebody come to me. Their father had a stroke, unfortunately, and he owns 6 properties. Okay, in his name, he has no estate plan and no powers of attorney. Okay, so this girl came to me and she said, we need to sell some of his properties because we need to pay for the facility that he's in and he can't manage all of these. Can we do this? And they don't have anything in place. And the short answer is no, you cannot. Okay, somebody needs to petition a court for guardianship of your father. And again, the time, money, attorney's fees, stress that's involved in figuring out who is going to be the person when we could have created a healthcare power of attorney. Both the healthcare power of attorney and the financial power of attorney allow you to designate a guardian of your person if you ever became disabled. And it's a checkbox. It's very simple and worthwhile to do. So the powers of attorney, I think, are equally as important as having a trust. If you have a business, okay, if you have assets in a business, something happens to you and you can't go to the bank and access your business funds, we create a power of attorney for you as the role in your business so that your business can continue on, and you can specify who has the authority to keep this going while you are gone. Okay, or not gone, but maybe temporarily not available. All right, so the same thing with successor trustee appointments. So in real estate, I've had situations, people own properties in a trust, all right, and maybe they are going through some sort of a health ordeal or they travel. In your trust, you have your successor trustees, and the language we use is if somebody is unwilling or unable to act as trustee, somebody else can step in. So again, it's just the ease with which you can give somebody else access to your things. Okay. HIPAA forms, I'm sure everybody's gone to the doctor. We create a HIPAA release that allows your doctors to know who you are okay sharing your medical information for. That is all part of an estate. Okay. Does anybody, I know you want to do questions at the end.
Yeah.
All right. I think that might be the end of my slide. So that is what an estate plan is. That is why we need one. I could give you examples upon examples of situations where they were beneficial or somebody could have benefited from it. But I was hoping that people would have questions or comments or things we could kind of talk about. So I think that's kind of the most valuable.
Yeah, so this interesting points that you made, you might want to touch on. I could take it.
Just speak loud.
The interesting thing is that how many people will need this?
Just speak. It's fine.
So how many people really have a will?
Right.
You can speak to so many people. I have so many clients that I ask them, do they have a will? And most of them say no. Who are you going to leave your kids to? Right? You get hit by a truck when you go to the movies. Sure. Too bad. Things happen, right? Who are you going to leave your kids to? Well, what happens is the husband and wife get into a fight because the husband doesn't want to give it to her sister and she doesn't want to give it to his brother. Sure. So, P.S., they don't do anything, sure. Right?
Yes, and that's what I find. I think most people that you talk to probably do not have an estate, even people that you would think would have one. And it's because it's hard to talk about and it's hard to decide, especially if you don't have a lot of family. That's also a lot of people's situations. And maybe they have family members that, aren't the most responsible, right? So I often get the question of, well, really, does everybody need an estate plan? What if you're single and you have no kids and you have, but if you own property and you have assets, you have money in bank accounts, you have, investment accounts. Okay. I present to you this situation. Let's say you have an IRA with $100,000 in it and you've listed a primary beneficiary on that account. What happens if that beneficiary passes away and then you pass away after them?
Yeah, secondary.
What happens?
Secondary kicks in.
If you have one. If you have one. You should have one. But what happens if you outlive both of them? Right? So that's what we do with estate planning. I ask you these uncomfortable questions. Let's say everybody dies. All right. We never want a situation where we don't know who your asset can go to. You can list the trust as a beneficiary, as a contingent beneficiary or a primary beneficiary. And in the trust, we say, okay, if my kids pass away before me and they have grandkids, they can go to the grandkids. If they don't have grandkids, then it can go here. I mean, we can, and you should in an estate plan take out the beneficiaries as far as you can take them. And then on your bank accounts, on any accounts that you have, you name the trust as the beneficiary of those accounts so that if those things all happen, we never have a question as to who gets these things, because where do you end up when we have no idea? We end up in court. And a judge will decide.
Here's another thing too. What happens? What happens What happens when you die and you leave your life insurance to your children as the primary, and then your sister or your brother or whatever as the secondary beneficiary, right? And the kids aren't 18. What happens then?
Well, then there's a question as to who has the right to take that money. And so any institution will find a reason not to distribute something that should go, right? So again, it's just you take care of that problem when you do a trust. We say, okay, whoever the trustee is, whether it's my wife or whoever, has the authority upon my passing, because we've named the trust as a beneficiary, that trustee, whomever it is down the line, has the authority to deal with this immediately. If I have a neighbor, unfortunately, her husband passed away suddenly, unexpectedly, very young. They had the house in his name only, not hers. So he has no estate plan, and they have kids, and they're 13 and 9. So under Illinois law, she owns 50% of that house and they own the other 50%. What do we do? Is her question to me. And you have to go to probate. You have to go to probate, and the judge has to determine that you have the ability to handle that asset until your kids become, of age. So it's just situations like that.
I'd like to know about trustees and how they work. So if you have a special needs adult and you need to leave her, how does that work? I mean, how does the salary work? How do you pay these people, and is it expensive?
So you don't. So generally speaking, a trustee is not somebody that you have to pay. When you are trustee of your trust, usually that trustee doesn't take a salary. Usually it's a family or a friend who you trust to do it. You can choose to say in the trust, I'll pay my trustee such and such dollars every month or whatever it is you want to do. You can specify, but that is not necessary. Where it does become necessary, so sometimes people say, I don't have anybody that I trust, but what about a corporate trustee? Corporate trustees are companies that actually will manage a trust for you, but there are fees involved. It is expensive. It's going to be a better option for you to find somebody that you trust to do it. And when I say find somebody that you trust to do it, it does not have to be your children, right? A lot of people automatically say, firstborn, secondborn, thirdborn. These are important things that need to, we have a healthcare power of attorney and a financial power of attorney, and then the trustee ends up being the person that handles finances and everything like that in the end. So it would be a good idea to have somebody who is good at managing those things. It is a time-consuming thing. And for healthcare, it's a very hard thing with the healthcare power of attorney to have somebody who's in a situation and you need to make a decision about their care. That is a hard thing to do, and not everybody is cut out to have that weight on their shoulders. So it's important to pick people who will do what you want. Right? I've had the situations where mom is sick and we have the document that says we don't want to prolong our life. We want to be more comfortable than keep us alive for the longest period of time. And then you have people that fight you on, right? So somebody who will advocate for what you want in those situations.
We had a couple of questions. Right there. Speak closer to the.
In today's day and age, there's no longer, I don't know if there's even a term for it, like traditional, normal families. There's like gentleman, lady, married multiple times, multiple partners, kids all over the place. Do you have a scenario that you've dealt with that's so complicated on how to tier who gets what?
So I wouldn't say that those situations are, 1,000 times more complicated than another situation. I have one actually that I'm working on right now, and I have, gentleman been divorced on his second marriage. He has 3 kids from that marriage. A partner, I won't call her his wife because they're not married yet, but they're thinking of getting married. And she's got her own 2 kids, and it's his house, and she thinks it should go to all of the kids, and he thinks it shouldn't. And so that can get trickier, but that's just where you need to flush out more and more situations with your client on, okay, what if you pass away first? what happens to these specific assets? And a lot of times people have very different opinions on what happens. I've had many situations where people don't agree. And the way to solve that sometimes, a lot of married couples will have one trust where both of them are co-trustees. If you truly can't get people to agree or they're unmarried, I would do separate trusts for each of them. So this couple, prior to getting married, I'm going to create a trust for her and a trust for him. And if they can't agree, they're going to have to figure out what assets go into which one. You know, whose kids get this? Are we going to do all 4 kids? And you can do all that. It's just getting them on the same page isn't always the best. I had a gentleman who hid from his wife where he was putting certain properties. So, I mean, people do things. People do things. And she found out eventually. But you know, you can do separate trusts for separate people. My father just got remarried, and you're gonna bet that I put everything that he has into a trust that the new wife was not on. So always, if we're making life decisions like that, where we're getting married, a prenup is really important, and I don't do that. So, but that in conjunction with some good estate planning is really ironclad. Okay, so that's
going to ask you.
yes.
Question is regarding probate, because you reference it a lot. Is there an estimate of what it would cost if people, I don't know, let's say they have $500,000. It's not a lot these days.
Sure.
And we leave in real estate. Like, typically, what will they end up paying to pass that on if it's not set up in advance?
Sure. That's a good question. And so what happens, particularly in the case of real estate, is when you go to a probate court, generally speaking, what you end up paying to the state, the county ends up being about 10%. Okay. So that's not in addition to attorney. So depending on how long this goes on, it can go on from a minimum of 6 months to years. Okay. If it's very complicated. I'll tell you that most probate attorneys that I work with, usually a minimum to get them started, they want a $5,000 to $10,000 retainer just to work on it. Okay, so the other option for real estate is if your estate is clean, and okay, let's say we pass away and we have 2 children. 2 children are still alive, so under Illinois law, they inherit. A title company will allow a sale to happen if the heirs are in agreement. But if you are selling it within 2 years of a person's passing, the title company is going to take 3% for something called a bond in lieu of probate of whatever you're selling that property for. Okay. And then there's just paperwork for them to do, and it just makes it a lot harder. The other example, and I think I maybe go ahead.
3% of that
$3
$500,000 property in this
Correct.
example.
Correct. And that's in addition to your real estate commissions, your regular title fees. So it's expensive. It's expensive. And then, you know, I always go back to this client because this closing we were doing was just a nightmare. But I had a gentleman who did a will. And in the will, he said, I'm leaving. My daughter is the executor and she gets everything. But she was not the only daughter that he had. Okay. So he passes away. She lists her property because the realtor doesn't know that we have to probate the will. She said, I have the authority. I said, okay, did we probate it? No. Do you have brothers and sisters? And was your father married at the time? He was. Okay. So your options are you either have to go through the probate process, which is, again, a minimum of 6 months, very expensive. And then, yes, you will be executor and you will be able to sell it and receive everything. But if you don't want to go through that process, then the spouse gets 50%. You and your other 2 siblings split the remaining 50%. And then when that happens, the title company will search the names of the heirs and do a search to see if they have judgments or liens against them. Sister that we don't talk to anymore had a $60,000 IRS tax lien against her that if we went that way had to be paid from the closing, and then everybody's proceeds were diminished by that. Okay, so we did not sell that property. She did go through probate. That could be avoided if the property was put into a trust. If he would have done a trust naming the daughter as the trustee and everything to her, she could have just done it immediately. So That's the best example I can give of that in real life that I've seen.
That's what I want. If you have it, revocable, you can change it. Who keeps it?
So
Can you repeat the question?
yeah, so the question is, if you have a revocable trust, who keeps it? So nowadays, a lot of people like to have documents digitally. What we do is we create paper documents. It's got to be paper. You have to come in and sign it, notarize, witness it. I will scan the originals so that we have copies. I will email them to you or whomever you want to have. Your financial advisor should probably have a copy. Okay. If you have kids or relatives that you want to have a copy, you can give it to them. So we'll give you the paper copy and we'll give you an electronic copy. You don't have to give it to anybody. Okay. So if you don't want your kids to know or whomever to know what you've left, and that you don't have to share it with anybody.
But we want to make it enforceable, because of course.
You have to find somebody that knows where to locate. So what some people do is they'll have, a safe or a safe deposit box. And if they don't want to give it to people, they'll say, okay, when I pass away, it's here. Somebody needs to know to go find it here. And you have to trust that person, right? Otherwise, again, I think your financial advisor is usually a good person to have copies of it. Your doctor will want the healthcare power of attorney for you. But there's no one size fits all thing to do. It should be in a place where it can be found in your home or online if it's needed. That being said, I've had clients that have found themselves in the ER and they're needing the healthcare power of attorney. And I get phone calls that say, can somebody send it to me? The nurse needs it. We can do that, right? So.
And since you pay for all to have it done and all that stuff, right? If you didn't like it, or you want to change it, you just want to erase everything and then start all over again.
Mhm.
If you do that, I think it's irrevocable.
With the revocable, yes. The irrevocable, no. You
So
cannot.
Once it's there, you cannot take it away.
You cannot. You cannot. You give up with irrevocable. I want you to remember, you give up control over the thing that you put in it. Okay. So you put it into an irrevocable trust. If you know you're never going to need to use the money from or whatever it is, that asset, again, yourself.
What is a living trust and how does that work?
A living trust is a revocable trust.
That's a revocable.
So a lot of you have a revocable living trust. And so that's the trust where you are the grantors, you retain the right to do whatever you need to do with your assets, or you can amend it, revoke it, do whatever you want during your lifetime. Now, if you're married, okay, and one of you passes away, that trust becomes irrevocable on the death of the first one. So you can't change it after that. But let's say, for example, you pass away, because husbands typically pass away. Morbid. Let's say you pass away. We have a trust where the both of you are on it. You can't change the terms of that trust, but you are the trustee of that trust. So let's say you have a house in it and you want to sell it. You can do that. And you can buy another house, would create another trust that doesn't have it. Okay. You could deed property into that trust again, as long as the beneficiaries and the trustees that you have there are still who you want. If you wanted to change it, you'd have to create another trust with different terms. Okay.
I have a question.
Yes.
Sorry. So as one of the financial reps in the office, a scenario that I often see is, let's say grandma owned a house. She died. She's been dead. And the relatives are still living in the house. They haven't probated it. They're paying the mortgage and insurance. And I'm like, oh my God, you guys have no right to this house.
Yeah.
Can you legally explain what happens in that scenario?
So it depends on, so a lot of times that situation ends up different ways in different situations. What should happen if it becomes apparent that the house needs to be sold and these people need to get out, okay, is a probate should be opened, or everybody can come together. So let's say we have, brother, sister, one's living in it, the other wants them out. It should be probated. People will avoid doing that. So you can sell the house if both are in agreement to do so. One can buy the other person out if they can afford to do that. A lot of times they can't, right? So you get into a situation where there is a court action where you can basically force somebody to sell the property, also very expensive. So it's an easier situation to deal with if everybody can come to an agreement. So either, one pays the other for it, somebody takes out a mortgage and buys the house entirely, but both have to be in agreement with what happens. If they're not, then it kind of, the lender who's been being paid, a lot of times they don't care as long as the mortgage is being paid. But if they did get wind of it, they could foreclose on that property because technically, there's an issue with who signed the mortgage and the collateral. So it can end different ways. Hopefully I answered your question. So court action should be probated,
right,
or an agreement to be made and they cooperate.
Yeah, because the scenario that I know thinking of right now, like I said, grandma owned the house. It's literally 2 generations now. So it's, the grandchildren who are living in the home. They have no legal title. They can't even sell it. Yes, they probably would like to, but they have no rights to the house. Like, so how could they even sell it? They can't, right?
Are their parents deceased also?
No. So it's grandma. They do have their aunts and uncles are alive, but it's the grandchildren who are living in the house.
So aunts and uncles would have the right to the property and they would be able to kick them out if they decided to do so. They would have the right to sell it if all were free.
Okay.
Yes, ma'am.
So let's say you have a trust and you pass away and the person who is supposed to be the executor refuses to be the executor. So what happens then if you have a second and third executor?
So the language of the trust is going to be if somebody is unable or unwilling, then the successor can step in. Okay, so if somebody just fails to do their duties, again, it's not something that's administered by a court. So somebody can say, I'm the successor trustee, I have the right to do this. They may be questioned about it, but say the first trustee is unresponsive, right? So something will need to be written, if you're dealing with a bank or whomever it is, a title company, as to giving them a reason that the first trustee or successor trustee can't do their duties, but the other person can step in if somebody's unwilling to do so. Yes,
You
sir.
can also name 2 people.
Yes, you can. I don't like doing that. Not that I don't like. I don't advise doing that, but yes, you can name co-trustees. So, let's say, for example, you have 2 kids, you want to make them both feel equally as important. But again, they have to agree. And with the amount of estate planning I've done and people passing away, people tend to sometimes have different thoughts, feelings, and emotions about what should happen with, mom and dad's stuff, right? So while I understand naming co-trustees, it often makes it more complicated. You need to have some.
Husband and wife.
Yeah.
And the husband says, well, I want my brother.
Right.
And the wife says, well, I want my sister.
Right.
Well, then what are you going to do?
You can make them co-trustees, but then we all have to hope that brother and sister agree on what needs to happen.
But everything's written down already.
Everything's written down in there anyway, but sometimes people leave people the discretion on when to sell something. So a lot of people say, I leave it to my trustee's discretion on when to sell my assets or liquidate things. Or you can keep things in accounts open for a while under a trust. So unless you leave specific instructions for the house to be sold right away or whatever it is, the trustee has wide discretion to manage the assets in the trust, for the benefit of the beneficiaries. And they have the ability to kind of discern what that means. So
We have a couple of questions on Zoom. I just want to get to those real
absolutely.
quick. So obviously a lot of our Zoom participants are out of state. Can you speak to the importance of what state you live in, the estate planning in your resident state, and what if you own property in different states?
Sure.
And we got a couple more.
That's a good question. So estate planning is a state specific type of law. Okay. Every law is different. Generally speaking, across the country, estate laws regarding what's called intestacy. So what happens to your property if you don't have an estate plan or a will is pretty simple. So if you pass away, you have a spouse, they get 50%, your kids get the remaining 50% split. But it is important to have an attorney from whatever state you live in do your estate plan. If you have one in place and then you move out of state, most times that's going to be fine. Okay. But I would say review it every 5 years is usually a good staple just to make sure. So you can have a trust if you live in Illinois and you have a trust that was an Illinois trust plan and you own property in Michigan, you can put that property in Michigan. And you might need to find a Michigan attorney to do the deed or a title company there to do the deed, but you can put property and real estate in other states into. Now you can't do any property that's not in the United States. That does not qualify. Okay.
Yeah, that was another question was, does estate planning cover assets outside of the USA?
So generally speaking, no. You have to look at the laws of the place where the property is located. Those laws will likely be different than here, and you should do an estate plan in those countries, but it's totally different than here, and your Illinois estate plan can't cover it.
Another question, can you speak to the benefit of estate planning for business owners?
Yes. So, yes, as a business owner, I know myself, I am a business owner, and it is me, myself, and I who makes all of the decisions. I'm on the bank accounts, and I do that. So it's really important, especially if your business is what brings your family their main source of income. If something happens to me, besides needing insurance, okay, and dealing with all of that, which Anthony helped me with, having a succession plan for your business. So you have to envision as a business owner what you see your business doing in the future without you. Okay. Do you want to leave it to your kids? You can put your businesses into your trust and address who controls who controls it if you're still here and you can't make those decisions. Those power of attorneys in your role as manager of that company or that business is really important. In your operating agreements, okay, so we do this in conjunction with estate planning, but if you have a company and you have more than just yourself, your estate plan is not going to be the only document that needs to be looked at when trying to figure out what happens after you are not able to manage it. So creating an estate plan that coincides with your operating agreement. In really advanced estate planning, you can have business succession planning where, you want to sell the business. This is who, let's say we have a manager that we say, okay, he wants to buy it from me, right? And we create a plan that determines how that process and the valuation process will go. So that's really advanced estate planning for most people. The trust that lists the business in trust and then the operating agreement that coincides with it is really the most important thing. There needs to be an assignment of your personal property, your business interest to the trustee of the trust within.
Yeah, I just had an issue about that. You just brought up a thing. If a woman, the wife, has all this jewelry that her mother left her that was passed down from generation to generation, and she wants her jewelry to go to certain people, right? And she's not happy to say, if I die, they're going to come in and take these pieces. I want this to go to her. I want this to go to him.
Yeah.
I want this watch to go to that person.
Yeah.
Right?
Right.
So in a will, you can put a list of all the people, right? And take pictures of everything so that there's no fuss once you die.
Right. And you can do the same thing in a trust. You can handle personal collections, memorabilia, things like that. You can be as specific as you want. You can restrict let's God forbid you have a child that has a drug or alcohol problem. You can restrict their ability to inherit based on their sobriety. You can be as detailed or as not detailed as you want to be, but you can do the same thing in the will with the personal property that you can in the trust. You should. Any gray area or vagueness, right, leads to interpretation and people's feelings so the trustees' feelings, they're human beings, even though we trust them, right, to do this. somebody can be upset. Somebody can make a decision that not everybody is happy with. So if you know that you want your china to go to your daughter, put it in there. If you know you want to be cremated, put it in there. Okay, so you can do all of that.
So the pour over will, right?
Yes.
That is something that kind of is a language that is beyond what the trust describes. But what if you have kind of conflicting things like that are contradictory between the pour over will and the trust? There's a trust.
So a pour over will, and thank you for bringing that up because I kind of glossed over the pour over will. A pour over will is a document that you receive in conjunction with a trust that you do. And when you'll notice, if you get a pour over will, it doesn't have specific information about beneficiaries. It doesn't have information about your assets, because what a pour over will does, and I'll give you an example of how this is used. A pour over will is created in conjunction with the trust, and it's a document that if, let's say I had a client who had a bank account, several bank accounts at Chase Bank. He passed away during COVID and he had 3 sons. He did a trust, and we deeded his real estate into the trust. So the trust applied to that real estate, but he never went to that bank and listed pay on death beneficiaries on any of those accounts. And he never put them into the trust like we discussed. Okay, so he ended up having over $100,000 in those accounts alone. So Chase looked at his sons and said, we can't give this to you. You need to go to probate. Okay, so when you create a trust, you also create a pour over will that says, Judge, if I have an asset that I have forgotten to put in my trust, I created the trust before I created this will. And I don't want my assets to be here in court here today. I want my trustee to handle everything in the manner that I've designated in my trust. It doesn't have specific information as to your wishes because that's really, you have a trust, it's private. Okay, so that takes probate from being this long process to a judge being able to look at that document and say it was not this person's intent to have his estate go through probate. It's clear that even though that asset is not in his trust, he intended it to be. Okay, so it's if something pours outside the trust, that's why it's called a pour.
So follow-up question to that. I know my mom has a trust and all that, but she's got this whole, in her own mind, which is where a lot of things are kind of crazy. She has a 4 or 5 page will that lists every item in the house. And she demands that I, of course, sell all my furniture. And my dad was a woodworker. So he's like 180 pieces of wood. I need them all.
Yeah. Yeah.
And so listed there. Now it's not in the trust, but it's in this huge long will. You know,
was the trust created before or after the will was created?
I think it was probably before. I can't remember.
Okay. So the answer is it depends. If there is a catch-all, so if the trust was created after the will and there's a catch-all,
maybe she just puts all my crap.
All my stuff goes to my trustee, then that trust is going to control.
The will is the same. That doesn't even matter.
Usually, if you want to do it properly, we would revoke that will.
So I'm not required to sell all my furniture?
You would need to probate the will. You would need to probate the will in order for it to be in effect. But I would look at the language of the trust and see what it says. But you don't want, so that's the other thing when you have multiple attorneys doing things, attorneys should be able to see the document that you have. And so if you have something that's in place and you're like, I can't find it, but I know it existed at one point. When you meet with an attorney to do a new plan or to do an update, we want to revoke the thing. There needs to be language saying, I revoke this document because I have a lady who I met and she's the sweetest lady, but she had 5 different versions of a will. No trust at all, but 5 different versions of a will. None of them were revoked, and they say things go to different people, and it's like it's a chess game where it's like, okay, who did what and when was this?
Right.
You probably need to go to a court for a judge to decide that. Yeah. Was she in sound mind when she did it? It does. a judge really would need to decide what ultimately happens, and it just gets so complicated.
We have more questions on Zoom. Sorry, guys. All right. So this one is someone specific in Illinois. They say, I have a will and a transfer on death on file with will in Cook County for my properties. Is that enough?
Transfer and death instruments, like a lot of people call them toadies.
Yeah.
Toadies are effective. Toadies, in my opinion, so a transfer on death, so everybody knows what we're talking about. If you own a piece of real estate, you can file something called a transfer on death instrument that stays on the title of that document. And so when you pass away, that property automatically goes to the people that you have listed in that document. That can be effective and good for some people. The question I beg to you is, what if one of the people that you've listed on that document passes away before you? Okay, so 9 times out of 10, will it be okay? Yes. What happens if the person that you list on that document doesn't want the property? It transfers automatically to them by matter of law. There's no deed that needs to be filed. It just is. Why I think a trust is better is, again, if that person passes away, you've listed who gets to step into their place. Okay, it's more comprehensive and complete to me to do an estate plan than the toady document. In order for somebody to inherit from a trust, a deed from the trustee needs to be given and accepted for that property to be transferred into that person's name. They can say no to that. And then you have instructions for you can treat that person like they've deceased before you. And it just goes to the remaining. So I feel an estate plan is more comprehensive. Could you be okay with that? Yes. But I also feel like that's piecemeal estate planning.
I have another question. So this person says they have family, they live and have family in Indiana. Their grandmother wants to put the house in trust and wants to leave the house to this person. But they want to figure out how do they do that? This person lives, in another state.
Okay. So you would have to find an Indiana attorney that could create an estate plan. It'll be very similar to the estate plans that we do here. And how to put real estate into a property is you have to do a deed. So from, say, myself as an individual to myself as trustee of the trust that I create. So it's a very simple process. Again, attorneys, title companies can assist with that portion of the process.
Okay.
Real quick. So if you made a trust when you were living in a previous house and then you move, what do you need to do? Is there anything that I need to?
Sure. Have you already purchased this new house?
Yes.
Okay.
I have a mortgage on
You have a mortgage on it?
Yes.
So all that would need to happen. And so sometimes during a closing, you can actually, right, when you purchase on a property, deed it into your trust at the closing. What would need to happen is you would need to deed that property into the trust that you already have. So just what's called a quick claim deed into the trust.
What would be rough estimate of the cost to create a trust? And then is there much maintenance down the road to review it and whatnot?
Sure. It's honestly a pretty simple process. I will tell you that there is a range. So it depends on if you need, just your very simple basic plan. I do those for around $1,000 for people that are associated with this group. Okay. We have to record the deed. So there are, fees to the county to do that, fees to a title company to do that. But my fee is about $1,000 for just a very basic plan. If you need more advanced estate planning, so if you need a special needs trust, if you need maybe 2 trusts instead of 1, or you're doing business planning, those plans typically start around $2,000, $2,500, but it just depends on what you have. So most people need the very basic planning. And I will tell you, a lot of people kind of are worried. The cost is the biggest question. It's just so much cheaper to do the estate plan than it is to let your heirs see what happens in court. So starts at $1,000, I would say, for a full plan, if you need the full plan. And then it kind of goes up from there if it's more complicated.
I got 2 more questions.
Let me just say one thing. And I'm older than a lot of the people here. I notice more and more of my friends getting sick and dying and things like that. Okay, and I've noticed recently that when people say, God forbid, we'll always say God forbid,
God forbid.
knock on wood. If you got a stroke, for instance, and you go to the hospital, and the hospital says, what do you want to do with this person? Right? And they can't find the information because he or she never told them where the key was or where it's
Right.
located.
Right.
Well, how much time do you think you have before they're going to have to make some kind of decision on this guy, right? So you got to really trust the people. You got to make sure that you will know who you want to deal with, trust who they are, and make sure that they're going to act on it quickly.
And that they're the person that shows up at the hospital with you when something happens. We have a situation in our family where there's grandmother's 100 years old. God bless her. Okay, she's with it, but she had an issue with her heart. She ended up needing a pacemaker put in, and they did have to revive her. She got 5 kids. One of them, I'll say, is kind of a ne'er-do-well. Has been living with her. I think is waiting for her to move on. Anyway. He shows up at the hospital, right? She doesn't want him to be making these decisions, but he's there, right? And he says, I'm power of attorney. Well, because we had the other power of attorney documents, the daughter was able to bring a document saying, no, he is not. And no, he's not supposed to have this decision. And no, he is not supposed to be the person you talk to about what's going on. So you want somebody to have it. People do crazy things, okay, when they think they're going to inherit money.
All right, so if you have set up a trustee,
Mhm.
trustee has a unforeseen accident, no one else was named, what happens?
Yeah.
So that's a situation when you could find yourself in probate anyway. So that's why a good estate plan, although it's sometimes obnoxious to force people to choose more than one person, I really have a hard time completing a plan for somebody when they name one person and that person can't. That trust is not going to withstand the test of time if something like that happens. So you could find yourself in probate again, because if that person doesn't want to do it or can't do it, who's supposed to? A judge is going to have to tell us that.
Okay, I got 2 more questions on Zoom. I think they're pretty similar.
Okay.
One says they have dual citizenship between Canada and the US. They have houses in each country. Would they need separate trusts and estate plans because they have different countries? And then another is similar. They live in different states, I guess dual residency in different states. Are there different laws for different states?
There are different laws for different states. And so for the state one, I would consult and kind of determine what laws you want to govern your different assets. Because in that situation, you can kind of pick if you truly are a resident of Illinois and then you're a resident somewhere else. You got to pick one. Mm-hmm. I would say, so for the short answer for the person who is a dual citizen of Canada and here, yes, you would need different estate planning documents for the assets in different cases.
That's all the Zoom questions.
Wow.
One last question.
How long does it take to create one and complete it?
Yeah. So that's a good question. So they can take a while. They can also not take a while. So it just depends on do you know who you want to be in these roles? What is your availability to meet? What is my availability? Usually I can be pretty available, to meet as long as we have the information. The fastest I've done one is 45 minutes from start to finish.
Wow.
But you have to know you have to know who are the people I'm leaving it to. And in order for it to be a good plan, again, the contingencies have to be out there. So if this person is gone, then who? If you don't know the answers to those questions, then we're going to have multiple.
And in the case of a person has different investments, different companies and stuff like that, do they have to combine all of them, or is it stated in there that all the financials are going to be in that?
Sure. So it's important. So let's say we have a house.
Repeat the question.
So he's asking, do we have to combine assets if we're doing an estate plan and a trust? So you do not have to. Okay. How an asset gets put into the trust is actually not something besides the real estate. I do the deeds for the real estate. It is actually up to you and your financial advisor to actually put your stuff into your trust. And so you can have many different accounts. And again, you can be as specific or non-specific as you want to be. So you can keep them separate, but the trust only applies to it if you either title the asset into the trust. So a bank account, we can make it some banks will allow you to create a trust bank account as trustee of the trust. In that case, it governs, or you name the trust as the pay on death beneficiary. If you don't do those things, either of those things, the trust that you create does not apply to what you have. So you can certainly keep separate accounts. You don't have to combine them. What you do want to make sure is that either your pay on death beneficiaries are pretty ironclad, or you put the trust as the pay on death beneficiary. You're welcome. Good question.
Very good. Can we give Lisa a Then awesome. I mean, the only place to go, an attorney will give you an hour of their time without charging you.
And I am happy to answer questions. If you guys think of questions, I am.
I did have one question I think would help. What is your process if somebody does want help? And before you answer that, we're going to pass out some evaluations. You just put your information on here. Let us know what you want to know. We'll make sure it gets back to Lisa this one.
I often find, I've been doing this for a while. I often find that when people reach out to me and they say, okay, I want to begin this process, my first step is to email you this. It's called an estate planning worksheet that I have. And the reason is I don't want it to be obnoxious. I know it's a little cumbersome, but people have a tendency to zero in on the things that they think are important, and then they forget to tell you about other things. Okay. So I have a worksheet that I email out to you that can get you started. So it literally says, this is my information. Am I a veteran? Am I divorced? Is there a divorce decree? Here's my automobiles. Here's this. Here's my beneficiaries, my contingent beneficiaries, my guardians. And I email that to you, and I want you to go through it, and I want you to fill it out as best as you can, even if you think the asset is not important. I email that to you. We can either meet when you have it ready, or you could just email back to me and I can start evaluating it and tell you what I think you need. That process can be pretty quick. I have to draft the documents when I have all the information, because a lot of times, even with that, people forget to fill in certain things. And that's kind of, we go from there. Once I have that back, I can draft the documents. I send you the documents to make sure it's what you want. There's no questions. And then we schedule a meeting for you to come in and sign. And everything is effective as the date that you sign it. So we take care of the witnesses, the notaries. The only thing that takes a little bit, and I don't have a whole lot of control over sometimes, is the recording of the deeds for properties. I do send those to a title company because it's just faster, but it can take a month. It can take 2 to have that process be done with. And certain municipalities have certain rules. So there are stamps sometimes that have to be obtained. Chicago has water certificates that need to be ordered and a whole bunch of extra stuff. So it's a process, but the actual creation of the documents, as long as we have the information, is pretty simple and easy to get started with an email.
You're asking for your email address?
Yes, I can give it. I don't know if you want to type it. It's LCP as in Peter, lawyer, LAWYER @gmail.com. Yes, it's LCP lawyer @gmail.com.
Screen too for everybody.
All right, cool.
Carmel had a question. Let me just try and unmute her.
Yeah.
See if we can hear her. Go ahead.
Good evening, everyone. I have a question. Okay, I was originally the person put on the trust for my mother initially a long time ago. And she always said that she wanted me to be the person to I was the power of attorney. I was the all of that. So now she's a little older. Her birthday is 80. Her birthday's today. She turned 87. I found out a couple of years ago, or maybe last year, that my youngest brother took her to an attorney and had everything switched over to him. So now he's in control. And I only found out by accident. So is there anything I can do in that situation?
So you were trustee of a trust and then you changed. Do you know if it was a revocable trust?
She did it so long ago, I'm not sure if it was, but I was talking to another sibling like last year, and she stated that he took her to an attorney and they switched everything over to him. And if something were to happen to him, then she would be the one, my other sibling would be the one that would make the decisions if he can't.
So my short answer without, reading and knowing specifics is as long as it was a revocable trust and your mother does not have any issues with dementia or memory or her capacity, then yes, that the revocable trust allows her to make those changes at any time.
Okay.
We don't, not being in the room with them, the attorney should have taken her separately and asked her if this is what she wanted to do outside of the presence of your brother. In theory, as long as she had the capacity to make that decision and it was revocable in the first place, yes, she can do that.
Okay.
All right.
Thank you.
Thank you again, Lisa, very much for being here tonight, spending time with us. Just like anything, I've been helping people plan their finances, just like many of our advisors here for a long time. The best time to plan is now, right? Because we get busy, we learn so much, and then make it a priority to take action on it. Obviously, I think Lisa did an incredible job tonight, giving us her time, answering your questions. I mean, you can see, I think if you like how she approaches and teaches, I think you'll like working with her. So please give us your information. We'll pass it on to her. She can reach out, and she also has your contact information. Thank you, everyone. Have a good night.